How to win check case. There are hundreds of videos suggesting simple methods even by drop of an eyelid to come out of check cases. But they do not visit trial courts where more than 90 to 95% accused are convicted. The remaining get convicted at appeal stage. Hardly 1 to 5% accused succeed who use technical defense. Even the experts suggest Supreme Court judgments. But most of such judgments are to judge judgments which are not binding on any other case. Such judgments are termed as obiter dicta judgments. Only 3 judge judgments and reference judgments are binding on other cases. The check law is document-based law and presumption is given to the documents. Most of the advocates, even senior advocates, do not have experience of contesting presumption-based laws. Since most of criminal and civil cases are contested on the basis of presumption of facts and law. For example, the America is superpower have most advanced weapons but it cannot fight the exploding population of rats rodents in its most important cities like Los Angeles. Our legal team deals with check-bounce cases from trial stage with legal actionable steps with proper results. First mistake of the accused is admission of documents on first date. Please note that it is not illegal to deny even the documents of the complaint, because the documents may be there but not legally proved and not legally presented. In this connection, we will mention recent 2024 Supreme Court judgment wherein the Supreme Court has deleted the observation of the High Court that the accused should not deliberately deny the documents. Even the Supreme Court has also observed that the accused has all the rights to take all legal defense. What are the legal defenses available? The accused normally defends on facts basis but which cannot be proved. For example, Rajpal Yadav has taken defense that money was taken for investment and not as a loan. It cannot be proved, so he was convicted. He is coming on YouTube or addressing press conferences that he has taken money and issued checks. Since documents are admitted under check law, the liability is presumed. Most of the advocates are stuck on the provision of legal liability in the law. But it was not a legal liability has to be proved by evidence in the court and not only just arguments. Once you have admitted the agreement and checks based on the agreement, so thereafter the accused cannot disprove it under the provisions of Section 58 of Evidence Act. What can be done? You have to take defense based on technical issues. Please understand that court cases are tried on the basis of mandate of law and on legal evidence only. Power of words is limited. Every situation cannot be explained or provided in any law. But you have very specific and must have expert knowledge of laws and its interrelation with each other. Even at appeal stage and even at High Court and Supreme Court stage, technical defense can be taken that 1. There was no jurisdiction for the trial court to conduct legal trial. The 5-judge Constitutional Bench of Supreme Court has mandated that once the jurisdiction issue is taken by the accused, it has to be decided prior to conducting trial. Second, there was no legal evidence, hence no proper cross was taken. So the accused can apply for further cross of any witness or even complainant even at the stage of appeal. Third is equal to there was no legal identity of accused or complainant and hence there was miscarriage of justice, so the matter should be remanded for retrial. Fourth and most important defense, that the documents and evidence of the complainant is not legally proved. Most of the evidence of the complainant is proved by leading questions, which is illegal for the complainant. But 1 in a million legal experts have made of videos on this topic alone. Without exception, any complaint case can be won by technical leading questions. There must be proper preparation for every questions and possible supplementary questions. The questions must be in rapid succession so that the witness have no time to think. The questions should be planned in rising steps so that once the witness replies one questions, he will reply in same manner for next questions. The accused has to give such applications with proper facts, laws and settled court decisions. Applications based on arguments only has no effect. You have to very minutely examine the pleadings of the complaint. We have not seen a perfect complaint anywhere in India. It is most important and settled law that accused should not suffer due to mistake of opponent or procedural mistakes of the court. But this has to be shown by actual facts and not arguments only. It is not possible for suggest general solution since the case history is separate for each case. Please send all the documents and our legal team will suggest actionable steps. We have also published videos on other channels for converting non-irrigated and waste lands in money-spinning machines. 1 acre land can be converted by most natural methods to give income of 1 crores to 5 crores in 3 years. Thereafter, a public issue can be floated for 50 crores where even foreign investors will come with pleasure since we show results for earlier 3+ years on a barren land. Kind by email for more details. Please tell in the comments that from which place you are watching this video and if facing check case what is the stage of your case. Thanks for visiting this video. Please subscribe since we continue to publish such videos. T has complete knowledge of leading questions. So they fail to take objections for method of giving evidence. We